Hey everybody, welcome back to another episode of Unfiltered HR. Today I have with me my friend Kevin Wicka. Kevin is as lucky as I am to work in the employment law space with clients, similar to my friend and lawyer and partner in crime in some ways, Heather Giambra. You get to see things usually further down the road after their little problems that can be solved in a business to where they're, escalated legally, right?
Absolutely. Thanks for having me here. It's nice to be here today to talk about these things. And as you noted, I like to say that the exceptions to things always end up on my desk. So, truth is stranger than fiction. I've definitely come to believe that axiom from doing this job. We certainly see a lot of different fact patterns, and I never cease to be amazed at what goes on out there. But we all either know people that have a job or we have a job. So these issues impact pretty much everyone in some regard.
Yeah. So Kevin is a partner at Tarantino Law Firm, right? And you've
Correct.
been there over 12 years? Yeah.
Almost over 16 now.
Oh my gosh, wow.
Yeah.
And you were practicing prior to that too, right? Yeah.
Yes, I've been a practicing lawyer for over 25 years, as much as I hate to admit that.
I don't know how you do it and keep your sanity.
Keeps it interesting every day.
Yeah. So you represent both employers in employment litigation and then at times employees, right?
Correct, yeah. I represent a lot of small to mid-sized employers. I also represent individuals in selective cases too, in all sorts of different employment matters. So we do both employment counseling and also employment litigation, whether that would be in federal court, state court, the Division of Human Rights, the EOC, sometimes dealing with the Department of Labor, different agencies. So it spans a fair range of things with the employment litigation issue.
Okay. So yeah, I'll ask you, and I think probably assuming most of the people that watch this are business owners, not employees, but and they've all been on this, what I think and what I've experienced is kind of like a wild ride of just like escalating truth being stranger than fiction type scenarios over the last 5 years. Have you seen that yourself, or in your, since you've been practicing long before this, have you experienced that things are kind of more wild than ever? Or what's
Yes.
Yeah.
I like to tell people that I think things have changed more in the last 5 years than they did in the first 20 that I was practicing.
Okay.
And I think it's dramatically different.
Okay.
Yes. A wild time is certainly what I would call it. Yes, you have to be nimble. I don't know that the law is caught up with all of the different technologies, the different current events that are influencing things. All of it's impacted in the employment context, in my opinion. It's been very, very dramatic as far as a lot of both changes in laws as well as culturally what's going on, and technology, which I'm sure we'll talk about.
And number of claims too.
Number of claims.
Yeah.
Yes, I think because it's so much easier now for people to be able to file claims on their own. Once upon a time, take the Division of Human Rights in New York State, for example, the person would have to have knowledge of the existence of that agency. Even before Google, they'd have to know that it was there, to go there physically and file a claim physically. Now everyone has computers in their phones and their pockets that are more powerful than anything we ever had, and they can not only access the information, they can easily, through user-friendly portals, they can file claims on their own. They don't necessarily need attorneys to do it. And some people would argue that there's some good in that it opens up the justice system to people, but it has really had a large proliferation of claims, and we're seeing, especially at the Division of Human Rights, a record number of claims for sure.
New York State, which is probably no surprise again to most of the people listening that I track kind of like case and claim numbers through just different like webinars I do when I'm trying to articulate like the significance of having proactive policies and procedures in place, or training managers or whatever, to demonstrate like this problem's only getting worse, especially in our state, and certainly like New York State's always number one or number two usually on the list of states with claims.
Yeah, and I found, especially really since COVID, it became really easy for individuals to file claims. And the division, for example, was investigating almost all of them. And they've made some changes recently. They announced some new regulations as of September of this year, where they have changed their intake process.
Okay.
So they're making jurisdictional determinations now over claims. If they don't believe it's within their jurisdiction, they're not investigating it where they were before. They're making some jurisdictional determinations over who is potentially a respondent. So just because a claimant named a person, whether it might be an individual or something, or as an employer, that they might feel this is not an appropriate defendant or respondent, they would call it there, then they won't allow that claim to go forward against that person. And I think I don't want to speak for them, but I think they've had to do that based on the volume of claims, that it just became overwhelming.
They're being more selective.
Yes.
Okay. Well, that's good news for employers.
I think it's good news for everyone, because it's just, even I can tell you too from employers that when they receive one of those claims, it's very upsetting. There's a lot of people that will say to me, I'm not doing this. I'm not treating this person in a discriminatory manner, and they want this process to be finished. They want to feel that they're vindicated, and it's taking a long time. So they're hoping to fix that.
Yeah, right. Yeah, it obviously is personally, I mean, it's a pretty personal claim to accuse someone of being discriminatory or something like that. So yeah, I see that too with my clients all the time. And
absolutely.
Emotion takes over, and that's never good for them when they're making every other decision that comes after that. So
I tell clients, emotion is the enemy of logic.
Yeah. Well, that's what we're going to try to do today, is be logical on the subject.
Sure.
So, yeah, we're going to get into the topic of today's conversation is really a hot topic right now, with kind of a lot of current events that have gone on in the past just few months, but really, again, probably the last 5 years in general, where kind of like cancel culture and things has been at an all-time high. And that is the topic of really free speech at work, in the workplace, and really kind of similar personal liberties that we all enjoy as individual citizens in this country, and how they may or may not come into play in the workplace, which I think people are finding out the hard way right now.
For sure.
Employers and employees, really. I mean, and I think another theme of our conversation today, as we talked about before starting, is there certainly is actual like things that you can and cannot do or say and not say, legal do's and don'ts, but then just, I'm sure, as you know, in dealing with clients just like me, when we're advising them, it's like, well, this technically isn't illegal, and you technically, aren't allowed or aren't not allowed to do this, but what you should or shouldn't say, or should and shouldn't do. Practical advice, yeah.
Practical is important, and we'll talk about the legal side of it, but I think we would be remiss to not talk about the practical side of it, especially in this day and age. For a lot of employers, it's hard to find help. So sometimes you have to weigh the legal risk versus retaining people, being able to keep someone. Is there a way to discipline someone? Is there a way to coach someone? Versus taking a termination route, for example. So we can talk about some of that. I do think the issue of speech in the workplace is widely misunderstood by most people. The issue of what is a First Amendment right and where that applies, whether that's a private employer or not, that's widely misunderstood, and I'm sure we'll get into that a little bit.
Yeah, well, let's just get into it then.
Sure.
So what is the general overview of the misunderstanding of that?
Sure. Well, the First Amendment protects speech from the government. Right? So in theory, what that means is that you should not be have action taken against you, like, for example, being charged with a crime or imprisoned or something based on something that you say or an expression that you may make or something. That does not necessarily mean that a private employer has to tolerate whatever your free speech is. Now, there are a lot of exceptions to that, which we'll get into. But that is where we really have to start, right then and there. There is no First Amendment right for free speech with a private employer.
Yeah, or really just one another. So, and your employer is a private citizen, a private individual person, right? I mean, it is now an employer, an organization is an entity. So you're right, that's where it starts to get gray. But the protection is against the government taking action against you for your speech, not individual citizens.
Right, and that becomes a little more gray if your employer is a governmental entity. There are some First Amendment rules that can apply there a little bit, but it's not unfettered. You can't say whatever you want. And there's a difference from being terminated from a position versus being imprisoned for something that you say.
Mm-hmm.
And that's really the intent of the First Amendment, is so that the government can't take action against you. But it is commonly misunderstood because a lot of people believe that they have a right to say whatever they want in the workplace or on social media, for example. They might think, well, I'm not talking like that in my workplace. I'm talking like that in my own private social media page, which that's probably an oxymoron, calling it private.
Yeah, right. Especially, yeah, with a public page that you make public. Yeah, so I think that's important too, is to talk about kind of the scope in which we're talking about this activity, which could be things people say inside of the workplace, things people say outside of the workplace, but that their workplace and everybody that is in it can obviously see and read, including customers or coworkers and things like that. And then I think it's and we're not going to be just talking about A to B, like employer to employee actions here either. You know, water cooler talk, which I know that's just a complete analogy now because there are no more water coolers that people are standing around if they're even in the office. But yeah, discussions between employees at work, and you know, what protections do they have from one another, and what rights do employers have or not to be able to manage and regulate that, let alone actions. Also, I think we're talking a lot about maybe generally the idea of expression. So whether it's like something you're going to wear to work, like a t-shirt with certain writing or pins or hats, or, you know, hanging something up in your cubicle that's potentially political or divisive or, you know, offensive, this kind of all falls under the umbrella that we're talking about today, right?
Absolutely.
Yeah, generally similar rules apply.
Similar rules apply, for sure. And those are all factors that the employer has a right to consider. They have to be worried about their other employees, as you said, as well, their customers. There are things that could be seen by customers that can, for business purposes, that they may not want someone to express. They also have to make sure they're complying with anti-discrimination laws in particular. So even if you're talking about two people having a conversation within the office, if someone else is hearing that, they're being subjected to that in that environment, and the employer has to regulate that as well.
Yeah, I think most, again, business owners listening are probably well aware of their legal obligation to protect employees from one another and them and their managers and customers when it comes to the topics of harassment, discrimination, retaliation. We all get to enjoy those trainings every year, so we hopefully are well informed about that.
Right. And one of the big things that changed with regard to that, within, you talk about changes within the last 5 years, is it used to be for a long time that only your employees could sue you. Now, non-employees can sue you as well if they come in. So, for example, if you have a vendor that comes in to repair your copy machine, or you have a delivery person, and that person is subjected to inappropriate or unlawful comments in your workplace, that is ultimately something the employer can be responsible for. And that never used to be that way. The employment laws only applied to employees, so that is another change too. Another issue to worry about for employers about speech in the workplace.
Yeah, right. Employers are just, you know, responsible for managing the world through their workplace, really.
And there are defenses. That's why I know those trainings seem cumbersome, but if you do have trainings and you do have policies on these things, they can be defenses for employers. So that's why those things are important, even though they might seem tedious at times.
Yeah. You're so good, Kevin. All right. Well, maybe let's get into, you know, so I guess, would it be safe to say that we're starting from a place of that there is no protected right to freedom of expression or speech at work, generally?
That's the general start.
It down into
things
that are.
There are exceptions, and we can talk about some of those things, right? Because not unlike most things in employment law, there's very few things that are exactly black or white. There's a lot of gray, and we can talk about that with the exceptions. But correct.
But yeah, I think if you're an employee listening to this and you're wondering about that, like, that's a great general starting place for you. And if you're going to take nothing else away, I guess that should be the general takeaway, is you shouldn't go in saying whatever you want and thinking that you're completely, you know, impervious to consequence. And if you're an employer, don't start like licking your chops thinking that you can just start, you know, cutting people left and right the moment they say something you don't like, because that certainly is not the case.
Correct. Yeah. You have to do a really good analysis of what actually is being said. Is it protected speech or not?
Mm-hmm.
And that's the question. And then if it is, we have to look at the balancing, the factors that go into that. Can you do something about it?
Mm-hmm. Well, let's talk about what protected speech is then, and then we can talk about the scope of where that applies, again, even to conduct or things people are saying outside of the workplace on social media, and why that could still be relevant to the employer. New York State, I mean, generally federally, there is no, well, there is when we talk about things like rights related to unionization, right? And that's where
work conditions,
the most basic,
things like that.
Yeah.
So there are different rules under the National Labor Relations Act, as you referenced, unionization. Someone has speech about promoting a union in the workplace, for example, that would be protected.
Mm-hmm.
If they were talking about work conditions, that can be protected. And through the advent of social media, we've had some different cases that have gone back and forth as far as the National Labor Relations Board, as far as what is considered protected or not.
Mm-hmm.
And unfortunately, that does tend to change a lot depending on who's in the White House,
mm-hmm.
because they have a certain amount of control over who sits on the NLRB. And sometimes we see some back and forth as far as how those rules are applied. But in general, if the speech is about workplace conditions, if it's about unionization, that is protected.
Mm-hmm. And that includes, like, this is something I'm always having to discuss with my clients, complaining about managers and supervisors, complaining about wages, complaining about working conditions. So that could be temperature, safety, hours, schedules, but also talking about pay, right?
Correct.
That I always have clients that are telling their employees they can't share their pay information with others, but that's simply not true, because they may need to do that in their efforts to organize. And this, by the way, to make it clear, it applies to organizations that are unionized or not unionized or not even considering unionizing.
Correct.
The whole point is it's protecting their rights, including speech rights, so that they could do that if they wanted to do that.
Correct. Absolutely. That's the point. Because a lot of people will say, well, we're not a union shop, so that doesn't apply to us. And that is not correct.
Yeah.
Because they might be a union shop if they're able to organize, for example. So
right.
You're exactly right. The other thing too is, rare is it going to be that you're going to get this nice, neat post, for example, on social media that says, I object to my employer's wage policies, right? It's sometimes there might be profanity that's in there. That makes it gray. That upsets people. There's been a lot of different decisions that have affected that, where you might read it and think, well, that's a clearly inappropriate post
mm-hmm.
that the employer should be allowed to take action against. And we've had some inconsistent decisions over the years as far as whether or not that really truly was considered to encompass wages or work conditions,
mm-hmm.
for example. So that's where it becomes a little more challenging to make that call.
Right. Do you really want to find out? Yeah.
Right.
And then, what's the wise decision? Like, when you're considering what you have to lose with each decision. Yeah.
And that's a great point you bring up, because I always tell clients, I could tell you that what my opinion is, that I think what you're going to do is legal. That doesn't mean it's not going to take years and tie you up in proving that you're right and spending a lot of money in doing that.
Mm-hmm.
So sometimes just having some preventative medicine and weighing the practical, which we
mm-hmm.
talked about a little while ago, is a useful approach, as opposed to just saying, do I think I can win this legal argument or not? Because you might spend a lot of money and time proving that you're right.
Yeah, and then I think there's, like, not to go too far into these considerations, because we probably will get into it later, but reputational risk too, whether it's internal or external, right? Do you feed into this? If this person was likely to post something now, and you're basically handing them additional fodder to go after you with online, and then they won't be your employee anymore, and then you really have if you fire them anyway, and you will have no control over it, and you're just giving them more ammunition. So I tell clients all the time, it may just let it go, and it will eventually fizzle out. The more attention you give it, the more life you're going to breathe into it, usually, as well.
I call that the oxygen on a fire.
Yeah.
Sometimes the more oxygen you give that fire, that's exactly what it's looking for.
Yeah. So I think a lot of what we're talking about, and maybe we've kind of like danced around this a bit so far is, most when we see these, things in the news right now about employees getting fired for their posts, a lot of it relates to a lot of those like political and social kind of movement stuff going on in this country. And this isn't new, but I think it's like heated up more so recently again. Um, and I think that's where, so it might be easy for us to say, yeah, you have to let people talk about wages. They can slam their supervisor on Facebook if they want. There's nothing you can do. But the gray comes in with these, again, social and political posts. And then those, where's the line between those being kind of work condition related or not? And I do think there's been NLRB rulings that have said if they're complaints are maybe related to the company's policies on things like diversity, inclusion, and different things, which are social issues that very much have political affiliations right now, you still could be stepping over that line into protected free speech or protected speech violations, according to at least the NLRB protected rights. Yeah.
Yeah, for sure. That you're definitely getting into a protected category. I think that in some of these situations that we've seen that have become high profile that you reference, where people have been terminated for their speech, what both maybe the employers and the employees have underestimated is the power of social media when it actually gets viral.
Mm-hmm.
A lot of people are used to just commenting, and maybe they might have a few dozen or a couple hundred people that might see it or comment on it, but all of a sudden, once in a while, one of those takes off and it really gets the intensity of that laser on it.
Mm-hmm.
And people start naming their employer and they're getting tagged, and now it's tens of thousands or hundreds of thousands or even millions, which we've seen in some of these situations. And it becomes almost untenable for the employer that they have to act and make a statement and separate themselves from the employee at that time. And that's really the power of social media when it really catches that wave is really can be really something else for both employers and employees.
Yeah, just threatening the business itself, which
for sure
threatens everyone in it, including the employees, right?
Yeah, I had, you mentioned, do I have any interesting stories? I did have a client one time that called, and they had a really strange situation. Not so much involving speech, but kind of involving this power of social media that we're talking about. And believe it or not, it stemmed from someone in the building that was not their employee was coming down and using their bathroom from a different floor. And one of the employees for the client objected to it and had a little bit of a verbal confrontation about it. And the person that was coming from another floor essentially raised an issue that they felt that it was discriminatory, that they were being challenged about using the bathroom. And they took their concern and named the employer online. And it ended up getting this kind of traction. It wasn't national viral, but it became enough locally that it became a problem where they essentially had to shut down their website. They had to shut down all their social media. Their phones were being inundated. So it really is something that can become overwhelming. They didn't know what to do. It was almost paralyzing to their business.
Right.
And it stemmed from something as ridiculous as someone just coming in and using their bathroom and an employee getting into a verbal altercation about it.
Well, we'll talk about ways to avoid that, or create policies to allow them to maybe prevent employees from. Well, that's a crazy situation, because that wasn't even an employee that was using their name on social media. It was someone not even associated with the business. So
correct.
Yeah.
But it just
no recourse there.
I think it illustrates the care that the employer has to take in the considerations that have to be made when an employee is out there. And that wasn't the case in this example I gave, but we have a lot of these situations where the employee is out there on their own social media page making statements about current events. And as we know, a lot of those things can run really hot. And it can come back onto the employer, because people will say, we want to find out where this person works. They start tagging that employer, and now this employer is forced to address this issue.
Yeah, because the internet mob is looking for some sort of justice for the wrongdoer, and they're going to pressure the employer to be the one to exact it.
Exactly.
Yeah. Employers are so lucky to play all these roles in the world.
This is there, and that is why I think a lot of them have policies and have to try to educate their employees on these issues, because a lot of people say things there and they feel they might just be like chatting with their friends or a small group.
Right.
But when you are putting it out there to the world, it can be picked up.
Yeah. Okay, so I think kind of I'm having this thought as we're talking, and it's reminding me of the concept of employment at will overall, right? So like actually it's funny with some of my clients, one of the first questions they ask when we work together is employment at will real? And it's like, I can't really give you a yes or no answer. I mean, technically, yes, right? Employment at will exists. New York State is an employment at will state, which means that the employee can leave at any time without giving you notice and having no obligation to you. And you, the employer, technically can fire them at any time without any reason,
Yes.
or even giving any reason. However, you just have to make sure that you aren't firing someone for a reason that is illegal. And so if you're going to let someone go, you better go down the checklist of all the things that are legal reasons to fire someone, and make sure that even in perception land, that you're not potentially doing it for any of those reasons. And I think that's similar to what we're talking about with regulating speech or expression at work. You're allowed to as an employer. There's nothing saying that you can't in some ways, or there's no rights to freedom of expression or speech, except for the few areas where it is either explicitly protected or could be construed as being protected because of other protections.
Yeah, for sure. And I think that there's a big difference when talking about employment at will. Sometimes employers, I'll have the conversation where they maybe confuse employment at will and having to give a reason for why they're terminating someone. So you're right. Under New York, there is employment at will, and in general, you don't have to tell someone why you're terminating them. We can talk about the tactical reason if that's a good idea or not, because sometimes it might be. We can talk about that, but if that person does allege a discriminatory reason, then you would have to the burden will shift to you to explain why you're doing what you're doing, and so that you still have the at will doctrine. And I would argue it still is a benefit for employers, because you don't have to prove that the person was a bad employee. Mm-hmm. You can still, at the end of the day, the burden is on that employee to prove the discriminatory reason. Tying that back to speech, you're right. We come from the place that, yes, that's the general rule. There is no First Amendment rule, but you should go through your checklist to make sure that, are we touching on anything? And then even if you think that it could be, there are other options which we can talk about of things that you could do. You could still make a business decision that this is, in this case we talked about, of these overwhelming waves of public outcry, that maybe they might decide to part with that employee and deal with the consequences of that.
Mm-hmm. Right. Yeah, business decision, take on the risk. Yeah.
Correct.
What's worse for the business? What's a greater risk? Yeah.
Right.
And if you have employment liability insurance, then it maybe becomes easier.
Potentially, or maybe you want a separation agreement. There can be a useful tool sometime to use severance. It's in order to obtain a release. It doesn't mean that you think you did anything wrong. It just, you want to buy your cost certainty, mm-hmm. because it can be expensive, as we talked about, to prove that you were right.
Mm-hmm. Right. Okay, so we have talked about speech protection as it relates to the employees' protected rights to unionize. What are other ways that speech or expression of ideas and whether they're political, social, or just construed as being such may be inherently protected?
Well, certainly anyone that would claim an argument that an employer is being discriminatory, or that someone's being harassed, or they believe the employer might be offended because they might say, well, this employer allows discrimination or allows sexual harassment. That is a complaint that is protected. Mm-hmm. So if, for example, here in Buffalo, we have a lot of Bills fans. Mm-hmm. If the employee says, well, I'm a New England Patriots fan, and I don't like that my employer does Bills Fridays where everybody dresses up, that is not protected.
That is the exact example, by the way, that I use as not an example of like illegal hostile work environment or discrimination when I do my sexual harassment trainings.
Yes.
The only safe category is talking about sports teams and the Bills. Yeah.
Yes, but you could have, in theory, two fact patterns that are identical. One is motivated because of someone's race, that's illegal. One is motivated because someone's not a Bills fan, that's not illegal.
Yeah.
Even though the conduct is the same in both. It's the why that is so important in these cases.
Right. Okay, so whether someone's complaining internally at work and talking to coworkers, or sends an email, or puts out a complaint on the Slack channel that, I mean, to kind of dip into the political, social realm, which is again where we're seeing a lot of this happen. Complaining that the business is not supporting, the BLM movement or something like that. I mean, where that's bridging the gap now is, could that be construed as discriminatory if an employer takes action on that and disciplining the employer, firing them for, even if the intention to do it is because they used the Slack channel or whatever it is inappropriately to talk about political ideas and things that they have a policy against, because that's related to race, that could be construed as racially discriminatory or retaliatory for expressing concerns about discrimination, right?
It could. I think it gets a little grayer if they're talking about, well, we want our employer to take a stand on this particular current event. That might make it a little harder, but I do think if someone explicitly states that they believe in some manner that their employer is discriminatory based on an action or an omission of an action, that probably is going to be viewed as a protected speech, even if it's not true, if the statement is not true. Their expression of that belief, it has to be at least reasonable, and that's a fairly low bar to have. They have to at least
getting lower every time.
Getting a little lower.
Issues, yeah, the policy.
So it has to be at least a reasonable belief that what they're saying is true. And if that's the case, yes, that could be protected speech. So that is definitely an example. We talked about unionization, discrimination. We talked about work conditions. So, for example, one of the ones I see a lot, maybe more on a federal level, is work safety. So OSHA, for example, someone might make some complaints regarding, they might feel that this is an unsafe place, or there is this issue, they express concern over the response to a certain condition that they're being exposed to, and the employer takes action against them in some regard, even if they hopefully don't say that's the reason why they're doing it, but sometimes the employee will say, well, I received a bad performance review, or I was put on a performance improvement plan and ultimately terminated because I raised these conditions a few months ago.
Yeah, right.
And that's a good point too. When is the speech engaged in? When did someone say that versus when is this adverse action taken?
Right.
And that gets to the question of causation. At the end of the day, the employee has to show a causal relationship between their protected speech and this adverse action from the employer. And one of the main components that courts will look at is what they call the temporal scope. How much time has elapsed between those two things?
The longer the better.
For the employer, for sure.
Yeah. Right.
Yeah. The longer the better. And you would be surprised at some of the court decisions that are out there that really don't like to go beyond a few months. Once it starts to get longer than that.
Really? Okay. I would always think it would be at least 6 months to potentially a year. I guess it depends on the...
There are some cases that will go as high as 6 months.
Matter,
they are a little more rare when they start looking at the temporal scope between that activity. Again, we're talking about having to prove you're right. That can be problematic. I think the average employment case right now in federal court is about 5 years. So that's a long time.
And how much money is that costing in legal
fees?
It can
be tens of thousands of dollars.
Yeah, I'm sure at least. Sure. Yeah.
So, do we want to get into that? Are there other ways in which we can talk about ways to try to diffuse these situations versus proving you're right in court?
Yeah. All right. So any other, if an employer is considering taking action against an employee for something that is, against speech or expression related, like we're talking about, whether it's a social media post or, a cartoon that they hung in their cubicle or something they said or a meme or gift they shared in the Slack channel, all these different things, right? What are other kind of like yellow lights or red lights that we should look for, where we should pause and think, ooh, this may not be something that's so clear cut to be able to take action
Sure. Is there consistency? So have we had situations where there are other employees that have engaged in similar conduct, maybe on the other side of the issue, that the employer, because maybe the decision maker might be like-minded with other people, has looked the other way on it,
So
right?
I've seen this, yes.
So that can certainly create a problem where we're going to enforce this because it's something that the decision maker doesn't agree with, but they look the other way.
They're emotionally involved.
They're emotionally involved.
Yeah, right. Consistency in general, I'm sure you would say this, and obviously you know this, but is, I think, more critical than anything else that an employer considers, because from what I understand and feel like I've seen, worse than even having a policy or a handbook or a standard in place in writing is having one that you're inconsistent with, or just being inconsistent in your decision making in general, especially when it comes to taking negative action against employees.
Yeah, absolutely. Consistency is important. There's no rule that says you have to treat everyone the same or that you have to treat everyone fairly. You just can't do it unlawfully. But you are opening yourself up to the allegation of unlawful behavior or unlawful treatment or
Well, right, because you're going to have to prove if you treated, Billy this way and Sally this way, what was the reasoning for the difference, especially if Sally's claiming it was for an unlawful reason.
Correct.
Why put yourself in that position?
Yeah. And
there could be a business reason for sure.
There could be. And we also have, there are just issues of, from a business standpoint, recruitment, retention, morale. It's generally a good policy to try to treat people fairly and evenly.
Consistently, right.
And consistently. I think it's important for that. But it doesn't necessarily mean it's unlawful. And even you can have situations sometimes, and again, tough spot to be in, but it is a defense. If an employer might have a policy, so let's take bullying, for example. An employer might have an anti-bullying policy, and it's not unlawful to bully someone. We talked about our sports fans, right? If someone's bullied because they're a different sports fan, that's not unlawful. Not a great business practice to allow it,
right?
But so you have to consider those things too. So you can have an employer could have a policy that's being violated, their own, and they could choose not to enforce it, but they are opening themselves up to that allegation, because not every policy the employer has creates a private cause of action.
Yeah, and I think when we get to the advice part of this, we can just kind of hint at it now, but it's going to be set a policy or practice that can relate to the types of expression that you allow at work, generally related to offensive, divisive, political topics of conversation and that kind of thing. And that's going to really, I think, be the big takeaway, is decide what your stance is on that as an organization, but then pick one and be prepared to enforce one that you actually intend to abide by in all situations, on all topics or ends of the spectrum when it comes to these discussions. Yeah.
And I think you and I have talked about this before, but just having the policy sometimes can be worse if an employer isn't aware
that's
of
what I was just saying.
policies they have.
Inconsistent, right?
Yeah, it gets into that. So if you're going to have these policies, you should make sure that they're updated. You should make sure that you know what they say, and that you are using them consistently. And that's where you come into play with stuff like that. And I know you've said before that sometimes having employers that have these policies that don't really know what they say is really problematic, because it's almost creating a rule book that can be used against them.
Correct. Yeah, for sure. Yeah, I would say if you used especially a third-party HR provider at any point, or if you're a business who's had a couple HR people kind of come and go and kind of loosely create a handbook for you or set of policies, then just so you had one, you kind of ask them to do it as kind of a check-the-box task. Pull those out at this point for lots of reasons, not just this subject, and go through it and make sure you know what's in it and you agree to what's in it, and that none of what's in there is really in complete contradiction to what you're doing in practice. Because when I get into my clients and they've used like a, I don't know, I won't name names, but any of the big kind of like payroll providers that may also sell an HR service or something like that with their payroll service, they're just kind of peddling these very generalized templated handbooks. And okay, of course, all handbooks start with a template, but they're not going through it thoroughly with the client and asking like, what do you want to do? And are you sure about this? And really discussing with them what it says and making sure it aligns with their intentions. And it's really actually maybe causing them more liability, concern than if they hadn't engaged with that provider at all, which blows my mind.
It's funny you say that. I remember a situation one time. I had a new client. They had one of these types of format handbooks that you talked about, and it had an anti-fraternization policy that prohibited supervisor-subordinate relationships. And I knew that they had several that were going on, including with people that were running the business. And so I said to them, are you aware that you have this? Because you're in violation of it. You probably don't want to have this because, and in fact, one of the couples ended up getting married. And so it was a situation where that really was something that just was right out there that didn't even jump out to them, that they weren't even aware that they were in violation of.
Yeah. There's been lots of clients that I've suggested, or at least I throw that out there as an optional policy. It's obviously not one that's legally required. And half of the time their answer is, yeah, we can't do that because we already know of like 5 people that are breaking that rule right now if we were to implement it.
Right.
Yeah.
Yes. Having it, you'd be better off not to have it at all than to have it knowing that you're in violation of it.
Yeah. All right. So let's talk about we've talked about kind of the legal side of things. And then I think, like we said, we wanted to talk about the practical, which, I think I would love if we could just spend more time in that side of things in the world or in life, in our work. But so I think like my personal view and takeaway is, I do believe that, if you are a person, whether you are on the employer side of things and the business owner side of things, or you're the employee in the business, I mean, if you have these rights of expression, whether it's the employer taking certain stances, on political or social topics while operating a business, whether or not it has anything to do with their business, you know what? If that is something you're passionate about, go ahead, right? If you're an employee coming to work and you're super passionate about something, fine, go ahead. You can say if that's important to you, then you can discuss it with people. But on both ends of that conversation, and especially for me when I talk with clients, is you can do that, and I think you should exercise your right to do that if that's what's important to you. However, you should be prepared for the consequences, and I think that's a message I would give to, again, an employee or an employer sitting in the room.
Yeah.
And ask yourself, is it worth it? Does it make sense? And really, why, what is the good that can come of this for you or anyone, even that movement or cause that you are so passionate about that's leading you to say this? I mean, are you really affecting anything positive by doing this, or are you just making yourself feel good in a moment because you're, expressing an idea that, makes you upset or angry or whatever it is?
That's a good test. It's similar to what I tell clients too, that you have to ask yourself, what am I looking to achieve by making this statement?
Yeah.
And especially we see this with the online or in writing or even in text messages. I can tell you that in almost every case we have the text messages that are exchanged among employees, among supervisors, employees, because that is a way that people communicate now.
Yeah.
They become exhibits in the case. They're all
so
reviewed. Right. And so if you're going to put something in that text message, if you're in a chat, a work chat, and commenting about an issue, is that something that you would want to be read out in court? Right? Why am I saying this? How will this benefit me? That's one of the things that I often tell clients, and I think you're spot on when you say if the only answer is it makes me feel good for the next minute.
To spout off because I got a dopamine hit.
And I got angry about this, and I'm going to put this person in their place.
Yeah.
That's generally not a good reason, in my opinion. And I think a lot of people have buyer's remorse when it comes to that. So that is definitely a good test. And I think even taking that a step further, addressing social media specifically, and that's where we've seen some of these high profile cases of people getting into arguments with strangers on social media. I would ask, what's the point of that? Well, how does it benefit me to tell the world, a bunch of strangers, someone that I'm arguing with, what I think about anything? Because you might even just change what you think about it in a certain period of time, but it's out there forever.
You posting your stance on some social or political issue is really doing almost nothing to affect that issue. I mean, you could claim it's raising awareness or whatever it might be, but generally, is it moving the needle? And how, again, like, for what the potential negative consequence, of that could be, is it even worth it?
Yeah, and I think filming, or I think really when you're talking about doing a thoughtful post versus actually getting into an argument with someone in the comments is really different. And that seems to be the latter, I think, what gets people in a lot of trouble.
The arguments, yeah?
The arguments, okay. Yeah.
I won't even go that far. I do, and I will give this advice too. I have clients that will, like, they're connected for some terrible reason with their employees on Facebook. And Facebook, I think, is the worst of all the platforms.
Right.
And so they're constantly seeing the posts of their employees, including when they're complaining about work or, and they're maybe not naming them as the employer, but the employer knows what they're talking about, right? And it's just, why even engage in that? Why even expose yourself to that, to like emotionally activate yourself and then try to keep that out of your interactions with your employees at work, be tempted to comment or say something, or even frankly like coworkers and employees being connected on there, and someone's complaining about someone else at work and then they get involved in something. It's just not a good idea.
It's an extension of the workplace in a lot of situations that you would think as an employer that, well, why should it be my problem or my liability if these two employees got into an argument or said something on social media that's going to impact my workplace? But it does. Text messages that go on among employees can be something. If we see a lot of times, one employee might go to the employer and complain about another employee over text messages they received of interactions that occurred. I've certainly had some strange ones in that regard as well.
I can remember something that you told me about, yes. But yeah, I emphasize this and I think this is good advice for individual employees to understand, and I emphasize this probably is one of the biggest points of emphasis when I do the sexual harassment trainings now, is don't be under any misinterpretation that if you're having a private text conversation with a coworker over your private phones and your private phone numbers and channels, that isn't what you're saying over that isn't something that could come into the jurisdiction of your employer to have to take action on you with. Because if the person on the other end of that is offended, or you do say something objective, that is unlawful, right, as harassment or discrimination under the law, it could be something the employer is legally obligated to take action on, because that certainly is going to impact that person's comfort level in the workplace, and they have to take action on that. But for employers, I think like making sure your managers are also well educated on that topic is good for the reasons you mentioned, that all these interactions are being used in claims and lawsuits, but that they, again, remember that anything they say in there, even if it's alluding to or creating some perception of some sort of, feeling about something that violates one of these, free speech rights to be to not have a negative action taken against, could be a huge issue.
For sure. And the managers, the supervisors, that's a great point, because they're the front lines for the employer.
Right.
And their conduct ultimately is going to be imputed to the employer.
Yeah, we talk about that on here a lot. They are you, the employer. There's no difference. Yeah.
And that's why it's important as the employer that your supervisors, that your managers are aware of that. There's nothing worse than having someone come into a supervisor or manager and complain about a text message or something they received, and have a supervisor look at it and say, "That offended you? Come on." As you noted, they have an obligation to investigate and look into it, and it might be something that's truly unfounded. However, you have now tainted the belief of that employee that they were not taking me seriously because they gave their feelings of what they thought about it. I say, I'd say to the clients, have a poker face.
Yeah,
You don't have to tell them what you initially think, because you may not know everything either at that point. And even if you do the proper investigation and it does not turn out to be unfounded, you don't want to taint that because you tipped your hand in the beginning that you thought it was ridiculous.
Right.
And in it, again, talking about the practical side of it, we don't want to send this employee off now to go bring a claim because they think I didn't really get a fair shake in the way they looked at this.
Yeah, and that brings me back to kind of what I was saying before, and I think having a poker face from like an individual conversation, like conduct, response, reaction standpoint to things that go on with your employees is very important. But I think like bigger picture, if you're not a political organization that's involved in like, again, like social issues or things like that, is it necessary for you to indicate at all what your stance is on these things that are, again, super polarizing, like emotionally triggering topics? Because if you tip your hand, again, that you may lean one way politically or on a social issue or whatever you want to categorize it as, the portion of your employees, because there's going to be probably employees of all sides and points of view in your workplace that apparently or perceive as at least as disagreeing with you, are going to be charged now in every interaction they have with you. They may perceive that really your action against them is because of this thing they now know that you differ on, that rather than something employment related or legitimate, right? And so even if that's stupid, unfair, all these things that I certainly think that they are, like, it's just unwise. So yeah, I've had clients recently who they have things on their website about certain social movements and kind of things, whether it's racial things or gun rights or whatever it is, right? Abortion, these are all political issues. Like, if it's not within the purview of your business, you should do whatever you want, but you should maybe consider why it may be defeating your overall mission and inability to do good in the world. If it's creating noise in your workplace, then you're not going to certainly be able to deliver your product or your service or whatever it is that you're trying to do good with your business. So, I'm a pretty like principled person and believe in, business owners should be able to do what they want. But as we've said, is it wise to? And if you're considering the bigger picture, maybe you don't indicate, your religious beliefs in your organization. And, if you want to, great, that's a decision you're making, but understand there's going to be potential costs to that.
I think the consequence issue is the one that you have to consider, both whether it's legally, whether it's from a business standpoint. And if people are prepared to deal with that, then so be it. I have one client that tells me all the time his mantra is death before dishonor. But he also,
I respect that, but
I respect it too, but it is sometimes a hard philosophy to hold, and he's spent a lot of money on that. I have another client that owns a business, and he will often resolve different matters even more liberally than I would recommend to him, that I think he has the solid ground in defending some of these things, and there might be reasons why he would want to, but his philosophy is, my business isn't making money by spending legal fees and tying up my employees dealing with you. And so there are two different philosophies.
So he lets too much go.
He lets a lot go and will resolve things even that I think are not meritorious, and it can be a dangerous message sometimes to send to other employees that you're willing to do that. But that's his philosophy, and he's prepared to deal with the consequences of that, as is my other client that says death before dishonor.
Yeah, I know. You and I are in a fun position. We see it at all ends of the spectrum, and being, toxically empathetic or, toxically, I don't know what you want to call that, principled, I guess, stubborn, both come with
depending on your perspective. Right.
Yeah.
I think, as you noted too, the thing, depending on the way that someone is memorializing their views on something, it is something that's out there for a long time. And as you noted, it can come back to be used against you. Let me give you an example. Maybe not necessarily on a political issue, but it could be something that touches on an area of sexual harassment or race or something. If someone has a claim, the courts allow complainants to prove those cases based on circumstantial evidence. So that means that you can use information that would give the fact finder an idea of what are the beliefs of the decision maker.
Mm-hmm.
So what they've put out there in the world is relevant to that.
Mm-hmm.
So it is something where we do see social media posts, we do see text messages that occurred in chat groups or things like that. And nowadays you think that stuff doesn't exist. It exists. It's ESI, they call it. It's searchable. It exists forever. And your stream of consciousness that you might say on your back porch isn't the same as what you put out in your text chat that has employees or coworkers in it.
Yeah, it's funny because in some ways, like, my stomach hurts talking about this stuff, or like insinuating, implying to employers or employees that they should censor their own speech, right, or their own expression. Again, whether it's in the way they talk about their putting in their core values, or just in conversations with employees. I'm a huge person, like integrity, authenticity. I think these are all really core virtues and values. So I hate discouraging people from doing this, but I guess maybe, like, and now we're getting way beyond like employer business talk, but just, I guess, maybe considering the reasoning for your intention behind wanting to express something too, and that may is it I think I put in here, is it kind, is it necessary, and is it true, I think is a really good rule of thumb to consider. Again, ironically, I mostly represent employers, you represent both, and I think a lot of the conversation on this podcast is from the employer's perspective. But it's funny, and we're really talking about employers and employees, and they both need to consider the same things when they're
100%.
in the workplace. And it is often not in either of an employer or employee's best interest to unnecessarily discuss these things or bring these things into the employer workplace realm. It's just not. Is it kind? Is it necessary? It's true. Probably the necessary part is a no. 75% of the time. Right.
As much as we all think our opinions are important,
yes,
they're probably not that necessary most of the time.
Not to share at work,
Not to share at work. And even what you put out there in the world, that all matters too.
You're right. Yes, the way your personal life can integrate and affect your workplace. But yes, it's often not necessary to share online for anyone and everyone to see.
Right, and for the employers looking at it, when they do receive these or they see these statements from employees, they do have to factor in: do we take action? I think we talked, going back to what we were talking about earlier. Is this something that's not protected? Is this something that's going to be a problem for our business, from a business decision or from a legal decision? They might want to move against that employee. And so they have to do this analysis then to look at that.
Yeah. Combination of legal counsel, a good PR firm, even sometimes, right?
Well,
lots of voices at the table.
One of the things we're getting now too is a lot of conflicting rights when it comes to speech. Not only the First Amendment, but an argument we're seeing a lot is people claiming religious reasons, maybe why they want to say something or not say something. And so as an employer, all of a sudden, okay, what do I do now? This person has rights, whether they're gender identity rights, and someone's saying, well, this is against my religious rights, and the employer just wants to do the right thing. What do they do now? Right? And so
have
that's
you had
a big
real
challenge.
Cases of that in the last year, because now the federal decree, I would call it, is coming up to direct conflict with New York State's human rights law on the topic of pronouns and religious rights to not have to use pronouns. And
right,
what are you advising?
Well, there's still New York law. In New York is saying these are the laws in New York State, and if you're a business here, so you have to remember, and that's a great point, that a lot of times when we see a lawsuit, for example, it may have federal causes of action and state causes of action, and the standards are not always one and the same. And they're very different throughout the country. Some states are much more considered employee friendly than others. New York is considered to be not the most, but definitely it does have a lot of employee friendly laws. I think some like New Jersey, California are considered to be even a little more aggressive when it comes to employee rights. But yes, you still have to factor in that there's still New York State law. I think a lot of people think, well, things have changed, so I don't have to do this. But going to these situations, just because someone says it's a religious right, I'm not going to recognize that. Your religious right can't necessarily impact and discriminate against someone else.
Right? Yeah.
So there's a lot of difficulty for employers when those two things start to come into conflict.
Mm-hmm. Yeah. All right, so let's talk about maybe some practical steps to take or what to consider, or whether. So I guess first, proactively in guarding against some of this, or at least setting out a roadmap for what to do before you're in the crisis for employers, and then maybe move into if they have a situation, kind of how to break down what
Sure.
to consider. So certainly having some policy or combination of policies, through your dress code or through like codes of conduct. I guess you could have a specific policy on political or social issue expression in the workplace, something like that. Those are all okay things to do, right?
Those are okay. Not only are they okay, they're recommended.
Yes.
That you have them, you understand them, as we talked about, and that you train people on them.
Yeah.
And sometimes that's hard because a lot of people might seem overwhelmed with training, but something like this in particular, you would be surprised how many people don't understand that what they put out there on their social media page could be considered part of the workplace. It could result in them being disciplined. So if you explain that, you've told people that, it makes it a much more difficult argument for them to come after you for it.
So you think you should be like sitting down with a lot of my clients, obviously the handbook now is minimally like 60 pages, right? No one's reading that.
Right.
If you give it to them just straight up, they're not reading it. So a lot of my clients will create like an essential policy summary where we pull out the policies that we know are most likely to be violated, either intentionally or unintentionally, or things that just the more practical things that people are going to run into on a day-to-day basis, to make sure our employees are informed of it, the expectations are mutually set from the beginning, and therefore hopefully we're much less likely to have to run into issues and manage people back to the right behavior. So is that's something that you think should be included in like an essential policy summary and discussed?
Absolutely, I do.
Okay.
Because I just think that it would easily come up, I think, whether you're talking about your sexual harassment training, which everyone is required to do under New York State law, that the extension of the workplace is not just within the four walls of the building. And so it can affect from a sexual harassment standpoint. It can also affect from be an impact from a speech standpoint. So all of that, I think, is important to address for those purposes. And it would logically and organically, I think, arise from that discussion.
Mm-hmm. Yeah, maybe it would be a good idea, just making a note here, to even just amend the sexual harassment training. Well, I don't know. In New York State now, it's really not sexual harassment and discrimination training anymore. It's just general harassment and discrimination training.
Right.
But it may not be bad to take a little, detour and also talk about this kind of stuff in there, and just more broadly about conduct outside of work and how it's still
absolutely
is relevant. Yeah.
Yeah, I think it would make a lot of sense to come up in that context.
Yeah.
It's hard because training is a challenge, right? A lot of people view it as, oh, this is something I have to do. You'd like to have it to be effective because you want, like as you said before, what is the mission of this employer? We're here to do a job.
Right.
That's what we're here for. And I think that's really the bottom line.
Mm-hmm.
That what we all think, that we can all have different backgrounds and think different things. That doesn't mean that we can't bond together for our mission for the employer to do our job.
Mm-hmm.
And I think that's important because very few of the jobs require people to take these positions that they're taking that are exposing both themselves as employees or their employer or the employer taking the position, exposing them to liability or exposing them to backlash from the consumers, any of those things. So very few of those businesses require people to take those positions. They're unnecessary risks. So I think it's all logical to address these issues in the beginning.
So logical, Kevin, but people aren't logical.
They're
not.
Emotional. That's what keeps us in business. As I've said to you before, that the enemy of logic is emotion.
Yes, we're just always trying to emotionally regulate our clients so that they can be brought back to operate within logic. Yeah,
and that's why, and it's no different for any of us when we're involved in it. it's always good to get an outside third-party perspective on things to look at it.
Totally. Yes. I try to just stay out of emotional things in general in my life and just do work because I can stay logical there. It's much easier.
You can try, but we all know it's easier said than done.
Yes, yeah. All right. So when they're writing these policies, what are like safe words to use? And I think one of the things I was thinking about was focus on the behavior, not the words themselves or the necessarily topics themselves, right? Instead of defining kind of like a dress code, right? Like, have you seen these dress codes people have where they attempt to define everything that you cannot wear, and
Yes.
in doing so, when you leaving one thing out is implying that if it's not listed, then you can wear it, and so then it becomes this like escalating game of exclusion, I guess. So I think focusing more on the effect of the behavior and the speech and the expression, and the impact of it, the disruptive impact of it, and less the specific topics themselves. Is that smart?
Absolutely, because these topics come up, we don't even know what they're going to be a lot of times.
Mm-hmm.
Trying to get ahead of that and come up with a policy that would address all of these issues. There potentially are going to be issues that come up that we don't even know exist, whether it's a technology of something.
Can't wait. Yeah.
Or whether it's a topic, a current event, something that comes up. And I think you're trying to make your employees aware that these are issues that can affect them, but you want to give yourself enough wiggle room as an employer because you just are not going to be able to define everything.
Right. So instead of listing like no social topics, political, geopolitical, whatever type of things, more, offensive, divisive, that kind of language.
Yes, offensive, divisive, things that can impact the business.
Mm-hmm.
Right. I think that's an issue too, because that's a lot of it. A lot of what sometimes can affect people is this is going to cause a problem for us from economically, whether it's our clients or customers, the public in general. And so something that impacts negatively on the employer and their business is something that, as long as it's not protected under one of those categories we talked about before, the employer should have the flexibility to be able to take adverse action for that.
So promoting civility, professionalism, maturity in communication.
Correct.
And conduct. Okay.
All good points.
It probably sounds great to everybody listening, but yeah.
Easier said than done.
Yes.
Right?
Yeah.
So yeah, that's the trick. But I do think, unfortunately, a lot of these things are on a case-by-case basis.
Yeah, you're right. Yeah, and I think that's one way to, I don't want to say attack because that's such a negative connotative word right now when we're trying to be neutral and not divisive. But yeah, I think it's often less about even what is being said and the way it's being said, right? Is it hostile? Is it even threatening at some point, right? If people are getting very emotional on these topics, whether it's in writing or, in one-on-one interactions on things.
Right. Yeah. And we're seeing obviously a different level. Some topics tend to be more combustible than others. So yeah, it's really, I think it's going to be hard in any one policy to have an exhaustive list. And so I would recommend against that. I would want it to be still general enough that it gives the employer the ability to be nimble enough.
Like latitude to work within.
Yeah,
when they call you or I, and we can say, okay, what are we working with here? Like, how can we?
Right.
Yeah. Discourage this behavior in a way that will clearly be shown to be business related or violating a policy and standard that we set. That's what we're trying to do.
Yeah, and that's really the bottom line. New York has a law that in general protects people's outside. Often it was originally created for political interests, but also recreational activities. And a lot of the case law that's interpreted that law, where people have used that to say, hey, well, I made this statement outside of work, or I engaged in this activity. The courts have said it's not your activity, but the conduct itself. It's not. So, for example, it's not that you were a blogger that wrote an article, but it's the fact of the content of what your blog was that was divisive and caused a problem for this particular business that allowed that business to take action against that employee. So it seems a little bit of semantics or splitting hairs, but that's a lot how courts are interpreting that.
Yeah.
So, I found that law to maybe not have the teeth for employees that some people might think it has.
Yeah, and I think that's an important point too. It's like, that's the reason in these situations, whether it's this topic or so many others, to call a professional or consult with a professional, even just a gut check, right? Like with my clients before taking action, because it just simply certain words that you use over others will imply certain things. And again, whether it's semantics related or just whatever, interpreted meaning later, it can make a huge difference. And really, why did you take the action?
Measure twice, cut once.
Yeah.
Right? That's great advice. I've had a client that I've worked with for a long time, about 15 years, medium-sized client, has over 100 employees, and they always will call when they have a sticky situation. And, knock on wood, they've managed to avoid any major claims. And I think it's just a little bit of preventative medicine. And we come up with a strategy. That doesn't mean that we've always picked the right thing to do, but at least instead of, hey, we did this, how do we get out of this?
Right.
This is what we're thinking. And then we weigh it and then make a decision.
Get out of it with the least risk possible.
Yeah. And it's good for their business too.
Yeah.
It's not just trying to avoid the legal risk too. There is a factor that you can make. And I should note that sometimes a client might make a decision that might be a little more risky from a legal standpoint. That doesn't mean it's the wrong decision. They made an analysis. I think I may have mentioned to you in the past that I had a client that their particular industry is very difficult to find employees. So as we've talked about earlier, the workplace, it's changed so much. All these laws have changed so much in the last few years. They might have some long-term employees that they've decided, okay, we have a complaint about this particular employee. We could just let this person go, or we could try to train them. Is there some risk in doing that? For sure, because now they're made aware that this person had a complaint. There's a retaliation risk that could happen. So there is some risk in that, but they've made a business decision that they're willing to try that. And so far it's been successful over the last few years that they're going to do that, and they'll bring someone like me in or you in to work one-on-one with this person.
Yeah.
And that's not something everybody's willing to do, but it's a little preventative medicine to try to avoid the claim.
Yeah, it can pay off for sure. And I think people are, savable and changeable. It's not maybe a majority of the time, but it can happen if the delivery is right as well.
Yeah, and I think that is the key, right? Sometimes, certainly no one wants to feel like they're being sent to the principal's office and being scolded in some regard. So the way that it's done is very important. One of the things I'll mention to people when I've done this is, you work for a very good employer. They care about you. They value you as an employee, that they don't want to just terminate you. They want you to learn from this experience and be able to do your job, because we're all here for this mission that this employer has.
Yeah, if you do it in a disrespectful way that doesn't allow the person to save face, and or clearly you're, doing it in a way to just create a documented trail to then be able to let them go later. People are a lot of the times they can sense that too.
Sure.
How genuine are you being, and are you talking about progress and that kind of thing, or just clearly just wanting to document the conversation?
Right. Yeah. And I think there's a big difference to that. And so that was a particularly unique approach. But again, we talked about practical versus legal.
Yeah.
The legal academic side would have said just terminate this person, but they've come up with a different approach that so far is working for them.
Well, that's why you're good at what you do, Kevin. You understand nuance.
We try.
Yeah, no, I'm the same way. That's why.
But to your point, what we brought that up to bring it back is by talking to a professional first.
Yeah. So have some policy, or probably some set of policies between, like a social media policy, a dress code policy, standards of conduct policy. Maybe sometimes there's even, in our handbooks, there's media contact type policies, right? That say you cannot contact and you cannot speak to, inquiring media organizations unless you are a person in a certain position or have authority to do so. So
Correct.
A number of different policies, which is how kind of all these things work, that come together to, again, at least create a foundation for us to be able to go back to and lean on and cite and craft, a case for taking negative action if and when we need to. So that's a great step. And then I think we said many times, which is pretty much always brought up, regardless of what I'm talking about, is training your leaders and managers. So the HR person knowing that these policies exist and no one else is not going to be helpful. And
Right.
just a few top level people knowing. So your front line, basically anyone who has any people authority or leadership or management, authority should know these policies too.
Absolutely. Yeah. They're the front lines, as we said.
Yeah. So
and their conduct imputes to the employer.
Yeah. Yes. Okay. Any other tips, words of wisdom, advice?
I think that you have to keep an open mind overall, that each situation might be different. And that's challenging, right? You're saying, well, wait a minute, Kevin, you said we have to be consistent. And that's true. But a lot of situations...
Consistently nuanced.
Yeah,
cautious.
Consistently nuanced. Very few situations are the same. It's one of the things that keeps this job interesting, I think, is that I never cease to be amazed at the new things that will come up and how you address these things. And so I think having someone that has some experience in dealing with it in your corner that you can talk to and try to come up with a way to brainstorm and basically pick a way you're going to go. Because very few times, and this is hard for people to believe, can I say, yes, 100% this is what you should do. This is 100% what you should not do.
Yeah.
I wish it were that easy.
It also wouldn't be legally wise for you to do that.
Well, correct.
But, yeah, you can't guarantee
once
anything.
in a while, some people will say something and I can clearly say, you cannot do that. I can tell you that.
Well, it's illegal.
Yeah. But a lot of times it just doesn't fall that clear. And so we have to go on our experience and our finesse and our judgment as far as what we think is the best course of action, and try to work with the employer, work with the client to come up with a way to achieve that.
Yeah, I think going along with that, my advice, I guess, lasting advice, if I had to give one piece, would be to not react and to instead respond. So not reacting means citing those policies that you wrote, seeking advice and help, even if it's not formally engaging, like a Kevin or myself, just calling someone and saying, hey, this is what happened. This is what I'm kind of sensing is the right thing to do, but I'm not sure. Is there anything else I should consider? Because if you're emotionally reacting, it's probably not going to be the right move. And that goes back to the consistency thing and, idea and all of that. Again, especially these topics, which obviously the reason this episode is being done is, again, just really because of the kind of political, social environment. And so this applies to topics outside of that topic. But I think this is what makes it so heightened right now. And business owners and leaders and managers are individual people with their own opinions and feelings and views and affiliations. And the more you can separate those from the actions you take in your business, the better off you're going to be. And so if you start to see red at all when something happens and are feeling inclined to act quickly, you probably should not. So do not react, I will say.
The 24-hour rule is great.
Yeah.
It's generally using the draft feature in an email, or if you really want to say something and put something out there to the world, if you feel that strongly about it, you'll feel that strongly about it in 24 hours if you think it's that important to say. Yeah. But that goes back to our emotion statement, that firing off statements in the heat of the moment rarely is a good philosophy to have.
Right. Employee or employer, whoever you are as a person,
Either
can
one.
get you in hot water.
Yeah, for sure.
And rightfully so, All right, any fun stories you can leave us with, Kevin? I mean, if we don't, I know I often feel like I have to laugh so I don't cry in the work that we do.
Well, I can remember I'll even give you more of a personal one years ago, a long time ago, not at my current firm, I'll say that. Okay. But I had a situation when I became this would give me putting on my hat as an employer, not as a lawyer, but I got a call from a client that was working with one of our junior attorneys at the time. I had just become a partner, and they had a very specific complaint about something that they said that our junior lawyer had said to them. And I didn't think that would be true. I couldn't imagine that the person would have said that. But I ended up saying I took some of our advice that we've talked about. I took in the complaint and kept my poker face and said, I understand why you're upset about this. We're going to look into this thing, and I'm going to get back in touch with you. And I took all the information, and then we looked into it, and there was some truth to it, which was really surprising. And there was sort of an explanation for it, which wasn't very good, but we had to take some action with regard to that as a firm. And so, that was one of the first eye openers I had, where I actually had to sit and actually not just be the lawyer, but actually have to address that as well. But when I look back on it, even after all these years, and it was a long time ago, I think, yeah, I did okay in that situation. We handled it right, as far as what to do.
Yeah. Well, that's good. You can see it from all perspectives, and we have no excuse not to do better, Kevin, because we know better.
Because we know better. But sometimes the shoemaker's children don't always have shoes. So, but fortunately, we do try to do it the best that we can.
Yeah, I have so many stories, but I feel like I can't implicate clients by telling them.
I have some good stories too, but maybe we'll save those for the next
someday
episode.
When we have some sort of podcast we can do totally anonymously.
Right.
Yeah. Oh gosh, yeah, the world should hear those stories.
For sure.
Well, thank you so much.
Thanks for having me.
Joining me. Yeah, I'll definitely have you back again to talk about other fun topics.
There's always something new to talk about in this field.
Oh God, yes, there is. But thank you so much. No, your advice is very good, and I know it comes with a lot of awesome experience and credible experience. And so if you guys are in need, hopefully you're not, but if you are, certainly keep Kevin in mind. We've worked together with a handful of clients at this point, and those are always fun, cocktail sessions afterwards with you and talking about those crazy things. Yeah. All right, check out the next episode. We'll be coming soon, and if you guys have questions about anything, certainly reach out, and we'll see you next time. Thanks, Kevin.
Thanks for having me.